Welcome back to WLINY's Finding Common Ground here on Altiste. My special guest is Joleen Cross. We were talking a little bit about family court, Supreme Court from the perspective of a litigant and a paralegal. We're going to still stay on topic a little bit, but the focus now will be how can we improve on family court? Family court is a very, very important court. It impacts on people profoundly. What do I mean by that? They can take your child away. They can say how you see your child, whether it be supervised in a room at EAC or whether it be supervised by your mother-in-law. They decide custody, child support, as I said, parenting time, adoptions, things that affect your family. They also do orders of protection, so sometimes children are not involved. It could be an order of protection between two brothers or a mother and son, but for the most part, children's lives are affected, parents' lives are affected in family court. They do a good job overall, I got to say that. It's not an easy job. You have these judges that have to decide who's the better parent with sometimes a little bit of information. Because even if you have a trial, does the judge really get to know all about the parents? The mother, the father. The father could be a great actor and come on the stand and portray himself as a great dad and not be. Mom can do the same thing. So we want to talk a little bit about how can we improve on family court. Now keep in mind, family court cannot give you a divorce. You can only get that in Supreme Court. So the first thing I would say, and I'm going to ask Joleen her take on that in a second, there's an expression that says justice delayed is justice denied. Now with respect to family court, you can come into family court, let's say in January, and then they appoint an attorney for the child. You come back in February. The attorney for the child spoke to the kids. The judge talks to the parties with the attorneys and says, can we settle this case? Let's assume the case can't be settled. Says, all right, everyone take out usually we take out your book, now you take out your phone. Let's pick a trial date or a series of trial dates. Sometimes those dates are 2, sometimes even 3 months away. Now, Joleen, when you were in family court, and this is after the divorce, we came to family court, how long did it take before you had your full day in court with a trial?
A year.
That long?
Yep.
How come?
It was a lot of circumstances. I filed for custody in the end of the summer, and the referee that was assigned to it lost the election.
It was a judge, actually.
She was a judge at the time?
I believe so.
Well, anyway, she was reassigned to support magistrate, and then a new judge came in, and that was in the beginning of the year, and he didn't know the case, so he adjourned it a few times to get to know the whole thing, and then he set the trial date in April, and he decided to give my ex one more chance with the children, and let's just say the trial was reset to July after school ended.
That's right.
I had
That's a little unusual, but it's funny, as you're saying it, I remember the trial very well, but you remember the timing better than I do, because there was a long delay. Normally, in family court, there's a thing called standards and goals.
Yep.
A case has to come in and be done, with few exceptions, in 6 months. Your case did take longer than that.
Yeah. So by the time we got to trial, it was already the end of June, early July, and it was a couple days of trial. And then by the time I got the decision, it was 2 weeks before school started.
That's right, because we had to get the trial in because we didn't want it.
No.
They might not have cared if it was adjourned 5 years, but we wanted a decision before the school year started because you had 2 school-aged children. And I remember you got the decision. I read it first, and you won. It was a long decision, great decision, I thought, about 8 or 9 pages, and it didn't give you a lot of time to then change the kids from their school where they were to the school where you were.
Yeah, and my children at the time were 94 miles away in Staten Island, and I was living in a 1-bedroom basement apartment. So within 2 weeks, I had to find a place to live, move, register the kids, move them out. And you know what? They started on time, and that was how long ago? And they're honor students.
Many moons ago. So again, and a lot of things when I say I believe we can improve on family court, I'm in there every single day. I'm in the trenches. I'm mindful of what I say is not easily implemented. In a perfect world, you say I want a trial and you're given 4 consecutive trial dates in maybe 2 weeks or a month.
Right.
In reality, it doesn't usually happen that way.
No.
There are exceptions. When a case comes in now with a violation for child support, they have to do it within a certain period of time, and I like that They're forcing the attorney's hands, but things are getting done. Or a neglect. If there's an allegation that a child is being neglected and they take the child away from the parents, they have to have a hearing. In fact, I remember one time where I had a hearing. It lasted till about 9 o'clock. It was Judge Genshi. We prevailed, and my client got her 3 kids back, and it was 9 o'clock. And people say, well, doesn't the court close at 5? This was a neglect. It had to get done. If it went to 10 o'clock or 11 o'clock, it had to get done, and it did get done. So before we leave item 1, we should try to get trials sooner as best we can.
Mm-hmm.
And I'll jump to the third one, where we should try to get the days consecutive. The hardest thing to do for a judge, I think, and an attorney, is to have a trial that maybe goes 4 or 5 days that lasts 6, 7, 8 months. I had a case one time that lasted a year, and we had about 6 days of testimony. How does a judge remember, even if they take great notes? And if I'm the petitioner or the plaintiff in a Supreme Court case, we go first. So let's say I put the case on the first couple of months, and then the case drags on for another 6 months, 8 months. The judge then hears the other side. Mm-hmm. Does that give them an advantage? Because he's hearing them the last, mm-hmm. at the end of the case. So he might have heard us in the beginning, but now he's hearing some potentially powerful testimony from, let's say, the father. The mother went first. That might be in the judge's head better than something that happened 7, 8, 9 months ago.
Well, there could be
Human
a good
nature.
side about it, that the judge already had a decision in their head and favored the one side over the other, even though they had both sides.
That could be. But if you had it close in time, I think it's more fair to the parties.
Of course.
Because you're right. There might be a judge that made up his mind or made up her mind. Or there might be a judge that hadn't, and then here's some good stuff coming from dad, mm-hmm. and then might have forget the great stuff that came from mom mm-hmm. 6 or 7 months ago.
No, these trials, they should be tighter together.
As best you can, and go day by day.
Because you don't want to go back and read the transcripts from 6
No,
months ago.
and then sometimes judges say you have to order the transcript. And that costs a few $1,000s potentially. I just had one recently mm-hmm. where each party had to pay a couple of $1,000s.
Yes.
Now, I do a lot of criminal work. I'm a former prosecutor. In a criminal case where there's a jury, the beauty is they bend over backwards to accommodate the jury. They don't want the jurors sitting there waiting. So once a jury is picked, they'll say, okay, be here at 11 o'clock every morning or 10 o'clock, whatever it is, and we're going to go. And the attorneys know, don't plan anything else. You're going to be there at 11 o'clock, and if you're not, you're going to hear it from the judge because they're going to make that jury wait. Kind of like, remember my cousin Vinny? And Joe Pesci was late. I think he had to get that new suit. And the judge had the jury waiting. The judge is on the bench, and he's tapping on, and he's looking at his watch. And he's saying, where were you? I've seen judges do that. But you don't see that really in family court or Supreme Court because there's no jury, so the judge will come out when the parties are ready. But if we could just make the trials quicker and make them consecutive days, I think that would go a long way. Another one is try to not waste any time, but try to waste as little time as possible. I understand sometimes you're going to have to stand around as an attorney or a litigant. You're not going to expect to get there 9 o'clock every single time and your case will be heard. There might be 15, 20 cases on at 9 o'clock. They used to stagger them some years ago. It really didn't work too well because all it takes is somebody's late and it's a mishmash. But attorneys should be mindful of a 9:30 start or an 11:30 start or whatever the case might be. What I like to do is if I'm going to be delayed and I know it, I will have one of my staff members or I'll say to the other attorney, look, I can't be there till 11. They appreciate that because they have other cases on. Most good attorneys don't only have one case on a day, so they can take care of other matters. By doing that, if I say I'm going to be there 11, let's say I get held up and I don't get there till 11:30. The other attorney is going to be a lot less mad at me than if I didn't call him at all and he thought I was going to be there at 9:30. So the attorneys can communicate.
I think that you seem to be the only attorney that actually does that because you're always sitting there waiting for another attorney. And
Doesn't it? It seems like
I don't even get a phone call from any of those saying, "Oh, tell Mr. Jusino I'm going to be late."
After the fact,
I think
I'm on my way.
the only one that does that.
And it's just common courtesy.
I think it should be protocol with all attorneys as a courtesy if they're going to be late to call. This way the judge doesn't even know what's going on because it's the judge that is waiting too, and they get frustrated.
I agree. And it's a little common courtesy. All you got to do is make a phone call. I'm going to be delayed. and the other attorney can then go to another courtroom, get something done. The worst is, I'll give you an example. There's many days I have 4, 5, 6 cases on, but even if I have 3, and I go to one, I'm thinking, let's get there first. So I get there first, and the attorney's not there. 5 minutes, 10 minutes, 20 minutes, a half hour. Then what do? Do I leave? Because now if I leave, then I got to come back there and I got to take care of another matter like today, kind of got jammed up. And then it's just, you hope to get lucky by being at a courtroom where the other attorney's going to be there. So that's a problem. And then what happens is if I wait too long, then the attorney finally gets there, then it's 11 o'clock and I got 2 other cases I got to take care of. If I knew that attorney was going to be there at 11 o'clock, I would have been done with 1 or 2 of the other cases already.
Well, that's
so it's time management.
The cell phones in this day, they can just send a quick text.
That's easy, right.
And a lot of the attorneys, you have their phone numbers, they have yours, and just say, I'm here, I'll be there in 10 minutes. Then, as a courtesy, they will be there and you can go and take care of the things you need to take care of. And,
Right.
and that's just it. Some of these attorneys, they don't have the chaos that you have, so they don't think it's a necessity to, give a courtesy text that, I'm going to be late.
But again, just common courtesy. Make the phone call. I'll be delayed. Also, we talked a little bit about it before, better communication between the attorney for the child and their own client even. Because sometimes I get a call, let's say the client's child, my client's child is 15, and he's calling his attorney. That's his attorney.
Well, that happened with my son. When we were going through the divorce, my son was adamant he didn't want to actually live with his father, and she wasn't returning his calls. And so he decided to email her. And you even told me what she said after she read the email. She said that it wasn't written by my son because it was too, quote, well written. And my son is a very smart kid. And for her to say that, it just dumbfounded that they don't take into consideration what these kids are really feeling and even sit down and talk to them.
And again, I know it's that many of them are busy. They have many cases. I know that the ones that are appointed, they don't make a lot of money per hour. I know it's a volumes game. You can't do 1 case a day. I understand that. But like I said, a little better time management, a little more courtesy, pick up the phone, say, look, I'm going to be tied up this week. I'll give you a call next week. That's what I do sometimes. Even if I get back late, I get back 5 o'clock, and I know I can't return 7 phone calls or deal with 7 clients. So what I'll do is I may call them. I called them 1 little while ago, and I said, look, I'm tied up now. I'll call you tomorrow at a certain time. Just a little courtesy. And especially when you're dealing with children. That child doesn't want to hear that their attorney's not available. And I know this is a cruel world, and sometimes you have to, you'll catch on early that not everyone's there for you. But sometimes it's important, and they want to feel that they have an attorney.
I do have to say, though, the attorney for the child, for my kids on my family court matter, very attentive to the kids, listened to me, listened to my ex-husband, and it was really nice to have somebody who was involved with my kids on a regular basis.
Yeah, the law guardian.
There are some good ones out
The
there.
attorney, and in fact, it was so long ago they were called law guardians. Now they're called attorneys, or attorney for the child. But that was a very good attorney for the child. She was very attentive, even though she was in a way not always agreeing with our position.
Right.
She had a job to do, and the judge can appreciate that. And the judge ruled in a way that didn't take into consideration what she wanted to do, because the age of the kids are important. If you have a 5-year-old, you can say, little Johnny should live with dad, even though little Johnny wants to live with mom. When you have a 15-year-old, things like that, you're really a mouthpiece for the child.
Right.
So you're really not supposed to undercut your client's position. You shouldn't say, the kid wants to live with dad, but you know what? He's dead wrong. Let the kid live with mom. They shouldn't be doing that any more than I would take out the legs of my own client. Say, my client's the better parent. Not really, Judge. No, but that wouldn't be proper. Law guardians should fight for their clients.
Yep.
So I want to thank Joleen for joining me for this half of the show. We're not done yet. We still have another half hour to go. Thank you for joining me, Joleen. It wasn't that bad, was it?
I'm going to need a drink after this. No,
she was fine. I really appreciate you coming on, giving me your perspective, and the viewers appreciate that as well. We'll be right back. I want to now talk about child support here in New York with a focus on Long Island. Now, the law applies to all of New York, but different counties have different little rules that have to be followed. how a petition is filed, what happens after that. I know Suffolk County and Nassau County Family Court, so I'm going to focus on that. And that is the area where Altice covers. So it might be slightly different in Onondaga County or something like that, but let's focus in on Nassau or Suffolk. Last week, I had Dr. Carlos Rivera on my show, and we touched on child support, but we didn't get into it in depth. I want to do that right now. In Suffolk County, let's say, or Nassau County, if someone wants child support, let's say it's a mother that has a 3-year-old child and the father of the child, it doesn't matter if they're married or not married, you would still apply for child support with a petition. We'll get to that. My producer's showing me a little sign. In Suffolk County, then, you'd file your petition. You'd ask for child support. You may have to establish paternity. What do I mean by that? If the parties are married, there's a presumption that the child belongs to that father, that he's the father of the child. It's rebuttable. So let's say the father comes into court and says, I don't think I'm the father of that child. They can do a DNA test, and if he's not the father, he won't have to pay child support. If he is the father, of course, he has to pay child support. So you may have to establish paternity if there's no marriage, unless there's a custody order. If there's a custody order, you don't need to do that. If there's no custody order, you'd bring in a copy of the birth certificate. You could bring in the certificate of acknowledgement of paternity, which the courts could accept. There could have to be a DNA test if the father says, I am not the father of that child. If the father says he's the father and the mother acknowledges he's the father, that's it. You go on to the next part of the case, which is child support. On Long Island and in New York, we determine child support based on what they call the Child Support Standards Act. And that, it's a numbers game. And let's assume somebody has a W-2. If they make a certain amount of money, 17% of their gross adjusted income goes toward child support for one child. 25 for 2, 29 for 3, and so on, is a percentage. Right? And it's gross adjusted. So what they do, they don't take out taxes, they don't take out what he puts in his pension, they just take out FICA, 0.0765, FICA Medicaid. 0.0765 you subtract from your gross income, that gives you your gross adjusted income. Then you multiply it by 17% for one child, 25 for 2, and so on. And then you divide by 12 if the person gets their salary per month, or if they get their salary weekly, then you divide it by 52. That's an easy one, right? It gets a little more complicated if, let's say, the father is self-employed, or he works off the books. Harder to calculate. If you have a W-2, it's easy. Even if you have a tax return, let's say from 2017, and let's say here we are, let's say it's February of 2018. We don't know what he's going to make for the whole year. Do we go by that tax return? Do we extrapolate? But it's too early if it's February to extrapolate. So the court has to do the best job that they can. They can go by that last tax return. Inevitably, the father is going to say, well, I always had overtime for 15 years. Now I'm going through a divorce. Or now I'm in family court. Guess what? There's no more overtime. So the court has to really decide, is what that person's saying accurate, or are they going to still get their overtime? And what's the overtime? Is it consistent? Is it sporadic? Some guys, let's say they drive a plow. They're going to make more money in winter than they're going to make in summer generally. So the court has to take all of that into consideration. Now, what happens when there's already an order in place? If the mom wants more money from the father, or if the father wants a downward modification, the party who wants the modification has to file a petition as well. But here it's a little bit different. Here they have to say there's been a significant unanticipated change in circumstances warranting a modification, or my salary went down by 15% or more, so I get a decrease, or mom can allege dad's income went up by more than 15%, she can get an increase. So these are thornier issues rather than setting child support the first time around. Because the father would have to prove that his income went down, if he wants a downward modification, through no fault of his own. He didn't quit his job. If he quit his job, the court can say, I don't want to hear it. You're going to still pay child support based on that amount of money you should be earning, even if you quit your job. Let's say the company went out of business. That's not the end of it. The father, in this case, would have to show diligent efforts to get another job, if at all possible, at the same pay. So if the father's making $50,000 a year driving a truck, that company goes out of business. There are other trucking companies. He would have to apply to those companies and other companies to try to replace the income that he lost when the company went out of business. Not always easy to do. What I tell a client, and it's not like the old days where you fill out an application and you submit it. Everything is online pretty much nowadays. So I tell the client, apply, apply, apply. And even if you have to apply for companies that pay less, still apply. So let's say the guy comes in and he says, I always made $50,000. I applied to 10 places that pay $50,000 and I couldn't get a job. But I applied to Home Depot and they're going to pay me $35,000. A court could say, all right, I'm going to set child support based on 35 because you tried your best to get a job at 50 and you didn't succeed through no fault of your own. Now, of course, the mother, the child, to some extent suffers because they're getting less money, but it's based on reality. Right? Now, the mother can say, I want an increase. I haven't received an increase in a number of years, and my husband or my ex-husband or the father of the child's income went up by more than 15%, which is what the statute calls for, one of the grounds. The mother then would come in and say, he's making more money, my child's needs have increased, they eat more, their clothing is more expensive, they have activities. Now the activities are generally add-ons. Child support covers food, clothing, and shelter. It doesn't cover add-ons. Add-ons could be extracurricular. It could be medical, uncovered, unreimbursed medical. Generally that's handled by a pro rata share. So if dad makes 100 and mom makes 50, dad would have to pay 2/3 of uncovered and unreimbursed medical expenses. Now what's that? If let's say the child has insurance, but there's a deductible, or there's a copay, or there's some expense not covered by the insurance, that is what you call an add-on, or uncovered and reimbursed medical. That generally gets paid in the proportion of their incomes. If they both make 50, then it's going to be equal. So we have modifications up and down. The parties duke it out in court, and at the end of the hearing, if they can't settle, the judge will say, I'm going to raise the child support, or I'm going to decrease the child support. Now, what happens if one of the parties is not happy with that decision? If for child support or the modification, any chain in that child support matter, they can file what they call an objection. An objection is like an appeal, but it goes to a judge of the family court. Because I didn't say this before, I was going to say remember, but I didn't say it. Child support goes before a child support magistrate when it's in family court, not a judge. If it's part and parcel of a divorce, it would be a judge. So the support magistrate makes a decision. Party says, I don't like it. They don't file an appeal and go to the Second Judicial Department in Brooklyn. It goes before a judge, and that judge makes that decision. If they're not happy with that decision, then they can appeal. Right? So an objection is like an appeal, but not quite. It's cheaper, it's faster. You don't have to order necessarily expensive transcripts and have them bound like you would in a real appeal case. Right? There's another component to child support, another petition that could be filed, and that is for a violation. So let's say the judge says, dad has to pay $100 a week, and let's say he doesn't. What happens? Mom can file a petition called a violation petition, that the father didn't pay child support as per the order. If she can prove that after a hearing, and usually it's pretty easy to prove. If it's through child support collection unit, they'll have a printout and they'll say dad is $10,000 in arrears. Or if it's paid direct, mom will say dad's $5,000 behind, and let's say he has no proof. He has nothing that he can produce. He has no canceled checks. The court will generally say dad owes $5,000. Right? But what happens? The court can say one of two things they have to consider. Is it a willful violation or a non-willful? A non-willful violation would be a violation that is not the fault of the payor. He lost his job. He still owes the money unless he gets a downward, but he won't be punished in the same way. There, the court could say it's non-willful, I'm going to hit you with a judgment. So mom has a judgment, she can go after any assets he has, any income he receives. If it's a willful violation, what happens? The support magistrate can recommend incarceration. She can recommend that he lose his license. She can recommend that he gets his passport taken away. The case then would go before a judge of the family court. That judge would then give the payor another chance to pay up and say, look, you owe 10, do you have 5? He could set what they call a purge amount. The purge amount is an amount that the judge sets that if the payor pays it, he or she doesn't go to jail. If they don't have it, the judge can say, you're going to jail until you pay that $5,000. Give them a 30-day sentence, let's say. You got to pay the $5,000. While they're in jail, let's say their parents or a girlfriend, a boyfriend, a friend comes forward with that $5,000. If that's the purge amount, they get out of jail. Now, the good thing is the law changed fairly recently where the judges now are under pressure to move these violation cases along. It used to be, okay, I'll give you a trial in, let's say, 6 weeks. Now they do it a lot sooner. You're talking about a week or two. Not the regular child support cases or the modification. That could take longer. But I'm talking about the cases involving a violation. And I've seen many of these where the client may say to me, I don't have the money. And then as soon as the handcuffs rattle behind them, they come up with the money. Sometimes they don't. If they don't, they go to jail. They still owe the money. They get out of jail. They still owe that money. But it's there to teach them a lesson and say, don't fall behind again. So the different facets, you have child support, you have a modification, you have a violation. You can also, a petitioner can also request maintenance in family court if the parties are married. If the parties are not married, they can't ask for maintenance. You can ask for maintenance as well in a divorce case, of course. So if you're married to someone, let's say they move out, they're not providing support, you can come to court for child support and extras, we just talked about that, add-ons, uncovered, unreimbursed medical. You can also ask for spousal maintenance. There's a formula now that they use to determine what the spousal maintenance amount is. So the payor could be the father. Now he has to pay child support and spousal maintenance. Right? So that's something that the spouse can ask for. If the father is not the moneyed spouse, they look at who's the moneyed spouse. In other words, who's making more money. They look at that. And the one who's making more money, and let's say has the kids, they receive child support maintenance. Now, a person can get maintenance and not child support because the other parent has the kids. So let's say the father makes a lot of money, but he has the kids. The mother could pay child support to him in some small amount if she's not making that much, and the father may have to pay her maintenance. Sometimes it could be an offset, sometimes it's not. So that's basically it. If you need more information, you can always contact my website, jusinolaw.com, or you can call my office 631-588-3155, and I can give you additional information. The last topic involves one of my favorite subjects of all time, Abraham Lincoln, Honest Abe. Abe Lincoln was our 16th president. As you all know, he was assassinated at the age of 56 by John Wilkes Booth at Ford's Theater. The topic tonight is going to be a little bit different than most of you are used to hearing. Most of the stories about Abraham Lincoln involve him as president. This involves him as a lawyer. We all heard about how he grew up in a log cabin, wasn't highly educated, taught himself most of what he ended up learning. And a lot of times they skip over the fact that he was an accomplished attorney. He didn't go to law school. He was an apprentice. That's how he learned the law. There's a story that he bought some books from someone, law books, and he read them. And that's how he started the education, becoming a lawyer. And lawyers back then, where today you go to a law school 3 or 4 years, you take the bar exam, you become an attorney, you might work for a law firm. I started out as an assistant district attorney here in Suffolk County. And that's how you learn the law. Many of these guys learned on the job. They were like an apprentice, just like a plumber's apprentice. They learned on the job. They honed their skills. They worked the circuit. Back then it was a little different. I hop in my car, I drive to Central Islip, and the courts are all there. Back then, they rode the circuit. What that meant was either stagecoach or a horse or a mule, and they would go to the different counties that had courts on at different times. It wasn't like every day the court was open. They might go to Cook County in Illinois on one time and then Metamora, Illinois, on another day. They rode the circuit. Now this case involves a murder case that Abe Lincoln was involved with. And he was involved with many high-profile murder cases of the day. And back then, attorneys were almost like the actors of the day. There were no movies, they had shows like Broadway. But in these towns where there wasn't much excitement, they would pack a lunch, they would go to the courthouse, and they would watch the giants of the day. And Abraham Lincoln was one of them. And they'd watch the trials. It was theatrics. Nowadays, some people go to court on an interesting murder trial. You see that. I go to court and Channel 2 News is there and there's a big murder case going on and people want to see the trial. It's like a show. Back then, that was a big form of entertainment. The attorneys were looked on as like gladiators. And in this particular case, a woman by the name of Melissa Goings in Metamora, Illinois, was accused of killing her husband, hitting him with wood. It was some firewood, because he was trying to strangle her. Now, when she first hit him, he didn't die right away. Supposedly, friends revived him, and he said, "Melissa killed me," or Melissa hit me, I should say. He ultimately died, and Melissa was charged with his murder. Now, at first, Lincoln wasn't involved in the case, so they arraigned her, they entered a plea of not guilty, and she was bailed out. They let her go home. Now, when Lincoln got in on the case, which is around 1857, so this is not that long before he became President of the United States, he took the case on and he said to the judge, "I need a little more time to get familiar with the case." He wanted an adjournment, which is very common when a new attorney gets on the case. When I say a new attorney new to that case gets involved. And the judge was not very happy about this. He revoked her bail. And he said to Lincoln, "I'm going to give you a little bit of time to speak with her." And that was it. Now remember, this is a first-degree murder case. Nowadays, attorneys would have weeks and months many times to prepare for this trial. He didn't have that. So what happened? And there's some different versions of what happened, but I'm going to go with the one that seems to be the more popular version, the more likely one. He asked if he could have some time with her to go over the case in a private room. So they let him downstairs so he could speak to her privately. A little while later, Lincoln emerged from that room and he went into the courtroom where a lot of people had gathered. Other attorneys, court officers, they weren't called that at the time, but officers of the court that were there to protect the judges and help out. And Lincoln shows up, but his client's not with him. So the judge is angry, and he asks Lincoln to approach. Lincoln approaches, and the judge says, where is she? And there was rumors at that moment flying around that Lincoln had helped her escape. There was even one witness that said, "I saw a woman climbing through the window." And Lincoln said, "I did not help her escape." And this is what he said, which is pretty funny. And I've read about this in other articles. And he said, "Your Honor, I did not chase her off. She simply asked me where she could get a good drink of water, and I simply said Tennessee." So he was basically covering for her. He didn't say, he couldn't admit to having helped her escape, but it's pretty ridiculous that a 70-year-old woman that was in the custody of the sheriff was able to get away. Now, did he help her escape? By my reading of the article, he had something to do with it. He was never punished. He was never sanctioned, and there was no other evidence that he played a direct role in her escape. Could he have left the room and she escaped? That's possible. What's interesting is that the state's attorney that was prosecuting her in the first place never issued a warrant for her arrest. Because nowadays, if someone escapes from jail or doesn't show up to court, they issue a warrant. A warrant is a notice to all law enforcement out there that if you come across this individual, you take them into custody. Now, I'm digressing a little bit, but I want to educate the viewers as to exactly what a warrant is. Now, people hear about a warrant, they have an idea of what it is. Different types of warrants. One warrant is what they call a bench warrant. So they issue a bench warrant because someone didn't come to court. Very simple. So if that person gets stopped in a motor vehicle traffic stop, the police officer sees there's a warrant, they take them into custody, and they produce them generally before that same judge that issued the warrant, if at all possible. And that judge will set bail or let them go if there's a good reason why they didn't come to court. Sometimes it's legit. I was in the hospital. Okay, come back on the next court date. Then you can have an arrest warrant. Now, what is an arrest warrant? An arrest warrant is where an investigation is done, let's say by the police or detectives of the police department, and they issue a warrant saying, we want you to come in, we want to arrest you. So there, the person hasn't been to court yet, but they will be soon. So back to the Lincoln story. So they didn't issue a warrant. That tells me something. They weren't too hot to trot to prosecute this woman. The judge apparently was. And Lincoln knew when the judge withdrew the bail, he revoked the bail, he knew where this judge stood. Now, if there was a jury, the story didn't say about whether or not there was a jury, but even if there was a jury, a judge has a lot of sway, the way he speaks to the jurors. Back then, maybe it wasn't as clear when the law was read, and now they have basically a script, and the judge says, if you find blah, 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 you must find him guilty. If you don't find that, you must find him not guilty. Back then, I don't know what the jury charge was. So the judges had a lot of say. They could influence the jury more than they can now. What's also interesting is that about a year later, in 1858, Lincoln was running for the Senate, and he came back to Metamora. And while he was there, he spoke to the state's attorney, the equivalent of the district attorney, and he had the case dismissed. So they really weren't looking for this woman. They didn't issue a warrant for this woman. But I suspect Abraham Lincoln had something to do with her escape. He might not have opened the door for her. He might have said, look, just when I walk out of here, go. And that's apparently what happened. And the person who wrote the article said that Abraham Lincoln was not perfect then, meaning when he was practicing law, and he was not perfect as the president. The myth of Abraham Lincoln was Honest Abe. And by all accounts, he was an honorable man, no question. But there were times where people wondered where his allegiance lied. And I can't believe I'm saying this, but I've read articles. There was an article where he actually represented a slave owner because he was following the law. Somebody had escaped. This man came to Illinois. It was a free state, but the slave escaped from a slave state. And his friends couldn't understand how Abraham Lincoln, who had always, and he wasn't president yet, he was a lawyer, had always railed against slavery. He was a man that had deep-seated beliefs that slavery was wrong. But yet, as a lawyer, he represented a slaveholder. So it's sometimes hard to reconcile, why would he do that? Now, as an attorney, sometimes I represent clients where I may not agree with their position. But there are some lawyers that, let's say a lawyer believes in a cause. He's a religious man, and he does not believe in abortion, let's say. He does not have to take a case that involves somebody that had an abortion, or civil rights cases, let's say. If you're a civil rights attorney, you don't have to take a case where a white man is accused of, let's say, killing a black man, and there are federal charges, civil rights violations. You don't have to take that kind of case. But here, and Lincoln described it away. I read the account that he was representing a man that he felt had the law on his side, because slavery hadn't been ended yet. So he took the position that this man was in the right, even though slavery was wrong. But slavery was legal in the southern states. Now, what happened when he became president, he spearheaded the 13th Amendment. If you've seen the movie Lincoln, most of that movie, all of the movie really, is about the 13th Amendment. The Democrats didn't vote for it, not one. But they had to get enough Republicans to pass the law. So what he did, and the movie talks about that, he had some people go out and give incentives. Maybe it was skirting the law a little bit, but gave them incentives as to why they should vote for the 13th Amendment. In other words, if you vote for it, you'll get this position. And to some extent, they got these people in line. And when the vote was taken, the law passed. The 13th Amendment ended slavery. Now remember, Abraham Lincoln signed the Emancipation Proclamation freeing the slaves, but it didn't free all the slaves because the South did not listen to that Emancipation Proclamation. And the North didn't have slaves, so it didn't matter. So what did that do? The Emancipation Proclamation was telling other countries like France, this war is about slavery. So don't let anybody tell you otherwise. You know, states' rights, yeah, that came into play. But the thrust of the war was about slavery. And once it was clear that it was about slavery, and it wasn't as clear until the Emancipation Proclamation was signed. Because there was states' rights. They could say, well, it's not so much about slavery, it's about our right to decide how we want to, whether we want to be free or slave, or any other issues for that matter, states' rights. But once the Emancipation Proclamation was signed, it became about slavery, no question. So a country like France couldn't get involved and help the South, even though they wanted to, because that would mean they were fighting for slavery. And their people would burn down that country. So that was a strategic move by Abraham Lincoln to keep countries that might want to help the South from entering the battle. But that was the official way that slavery ended in the United States, the 13th Amendment. Abraham Lincoln was a great president. I said earlier, he was the 16th president. I would argue that he is the best president that we ever had. We've had great presidents like Ronald Reagan, George Washington. I would say the best American all around was George Washington. He was a great president, but he won the war. He put us in a position where America could become a country. Remember, it was colonies. He won the war. If you ever have a chance to read some of the accounts on how he did it, it's fascinating. But Abraham Lincoln, great president. I want to thank you for watching the show tonight. If you miss it, if you miss future shows, if you're watching it, obviously you caught it. If you miss future shows or you joined in late or you had to leave early, go to YouTube, WLINY Internet Radio. You can catch the shows. There's a whole catalog of shows. Thank you for watching. Catch us next Saturday at 10 in the morning. I do a live show, which is a little more politically oriented, on Friday nights, this coming Friday at 8 p.m. You can catch that first on Facebook Live and then YouTube. And for your insomniacs, you can also catch the show Thursday mornings at 1 a.m. Thanks for watching.